If you're in charge of preparing the order, you need to be aware of a few things. First, the rule requires that it be submitted to the judge in 30 days. However, some judges give you timelines before that, so you need to abide by whatever the judge tells you. If the judge says it needs to be in by 10 days, get it in by 10 days. And the quicker you do it, the easier it is. I certainly have had times that I've been trying to decipher my very messy, quickly taken notes and struggled with it. So get it done as soon as possible. Some judges will ask you to go ahead and send it to the other party to approve, whether it's a pro se party or not. With another attorney, I always ask for their approval before I send it in. If it's a pro se party, it kind of depends on the circumstances. If the pro se party did not show up at the hearing, I might ask the judge if I need to do that because they don't actually know what happened at the hearing. Or if I could just submit it to the opposing party at the same time that I submit it to the judge. So I might ask that at the hearing. But you do want to send the order to the opposing party at least at the same time you sent it to the judge, if not also beforehand, to avoid that ex parte communication. Also, I warn my clients that nothing is official until the order is signed. Now, often if we have a temporary agreement to start temporary visits and temporary child support, sometimes the parties are trying to get along and want to go ahead and start, and that's fine. But someone's not going to be in contempt until the order is signed and then the order is not followed. So I just like to specify that with my clients. I do encourage them to go ahead and start doing it if they think that it will work out because it is good to improve that goodwill between the parties as soon as possible.
And be sure at temporary hearings or any hearing where you're before a judge, if the judge hands down a ruling and you are having trouble understanding it, do not hesitate to ask for clarification. I've had a case where the judge was saying 50 and I thought that she was saying 15. And it ended up making a really big difference. And it's actually really difficult to amend orders on the back end, and it causes a lot of confusion. So you want to get it right the first time. You want to make sure you share that with opposing counsel so that you're not writing a judge and saying, hey, I made a mistake and now I need to correct it.
I also warn my client to make sure they understand and follow the order, and it can be helpful to follow up with a letter to your client outlining exactly what you've discussed and just putting in more layman's terms what their responsibilities are, because those orders can be kind of large and confusing and overwhelming for people to read. So you absolutely want to make sure your client understands what his or her responsibilities are with the order. If your client willfully violates the order, they could be held in contempt. And when somebody willfully violates, the other party can file a rule to show cause, which is a hearing that gives that party an opportunity to prove to the judge why they are not in willful contempt of the order. And willful contempt generally means they purposely knew they were violating the order. Of course, there's lots of circumstances. It's a case-by-case basis, but for example, what might not be willful contempt is if my client was taking the kids to go see their other parent, the car broke down, and because of that, they weren't on time to visit the other parent. That's not a willful contempt, even though it's a violation because the kids weren't there on time. It wasn't a willful violation. So my proof in that case, if I was defending my client at a rule to show cause, would be proof of the car breaking down and maybe her testimony about what she tried to do to contact that other parent or to help make up the time that was lost with that other parent. If somebody is found to be in willful contempt, then they can face jail time, community service, or fines. And I've even had a situation where the violation of the court order was that my client allowed a paramour to spend the night when they weren't supposed to, multiple times. And ultimately, the child ended up, the other parent got custody of the child because the court found that it was in the best interest for that child to have to be at the other party's house because the other party was actually following court orders. So it's very important that you warn your clients about how this could affect not only their present situation with jail and fine and community service, but also the ending result of the case.
And generally, the party bringing the rule to show cause will ask for attorney's fees, and they're more likely to be granted attorney's fees over a rule than they would be, say, at a temporary hearing or something like that.
Discovery is now available in every family court case. It used to be that you had to ask for it, but the rule has changed. You no longer have to ask for it. It's Rule 25, and it's available for everybody, whether or not you ask for it in your pleadings.
So if you use someone else's pleadings, most people still have that in their pleadings. You're going to want to be with it and take that part out of the pleadings so that you're in compliance with the rule. You no longer need to do that.
And we listed some different types of discovery just to remind you what options are available. And I think this varies around the state, but where I practice, the attorneys are pretty good about voluntarily exchanging information. And so instead of doing a request to admit, for example, sometimes or a request for production, we can just ask for the document and the other one will give it to them instead of having to do the formal process. But I'm sure that does vary quite a bit by the jurisdiction that you're in, and it never hurts to have the paper trail and do it formally.
If you are going to issue discovery, think about customizing it to your client, because I'll often receive discovery requests and it at least appears clear to me that the attorney on the other side didn't customize it at all to the case before us, and any responses that my client did give wouldn't really be relevant to the litigation at hand. So you're missing an opportunity if you don't use your discovery to discover information that would actually be useful to your client. And I think just always be thoughtful about don't just go through the motions of submitting discovery or requesting even a temporary hearing. You want to think about if that is something that at that time is in the best interest of your client. Is there information that you'll be able to obtain? It's good practice not to find yourself just going through the motions. And so we're going to talk about your client's mental health records. This comes up a lot in my practice, and domestic violence and sexual assault survivors as well will tell you that one of their primary concerns is their privacy. What many people like to do is try to impeach a domestic violence victim's credibility by saying that they're mentally unstable, and so they're often going to go after their mental health records. You're going to want to guard your client's medical and mental health information unless your client consents to the release of that information. Mental health information is typically privileged unless there's a court order. So I routinely, unless my client consents, argue motions to quash or object in discovery requests for my client's mental health or medical information. And you can win on those sometimes if it's not relevant to the litigation before the court. For example, if your client's mental health is not affecting the child, or it's not adversely impacting the child. So I routinely argue against those. I would also encourage your client not to make it, if your client is, for example, actively in therapy or something like that, which many domestic violence survivors are, they don't necessarily need to disclose that to everybody that they talk to, because then they might accidentally be calling their mental health into question. So I encourage them to kind of hold that close to their chest and not make that an issue, because once it becomes an issue, at that point that gives the court grounds, pursuant to the two relevant statutes that are included in the PowerPoint, to go after or release or order disclose the client's mental health information. It's also really important because if there is simultaneously a criminal case pending, in criminal cases, the attorneys are really likely to want to use a survivor's mental health records or medical records to try to impeach their credibility. So I think as their attorney, it's really important that you jealously guard your client's privacy and their mental health and medical information.
I mentioned earlier that a guardian ad litem will probably be appointed at the temporary hearing unless the parties agree. The court will generally ask the attorneys whether they agree on a guardian ad litem. So even if you can't agree on issues such as temporary custody, temporary child support, and temporary visitation, it is worth trying to see if you can reach an agreement with the opposing party as attorney about who is going to be the guardian ad litem in the case. Most guardians are attorneys, however there are some that are not attorneys, and they generally have fewer fees if they're not attorneys, or the lower fees, excuse me. So that's worth knowing, asking around and figuring out who in that area does a good job with their guardian work, and also what their fees are like.
And courts will often limit the guardian's fees up front. I think that happens in particular when they know that the parties involved are under-resourced and might not be able to cover the guardian's fees. I never have, but I think you could feasibly ask that a court limit a guardian's fees. Of course, you run the risk possibly of, I don't know how that would necessarily affect the relationship with the guardian or something like that, but I think that's something to consider because guardian fees can become very cost prohibitive and sometimes force our clients to settle when they don't feel like they need to settle because they're very concerned about continuing to accrue those fees. So a cap in some cases levels the playing field for low-income clients.
In your case, you can ask that the opposing party be responsible for the majority of the fees, especially if some of their actions caused this case to have to be filed. In my experience, that hasn't worked, but it is possible and it's worth asking. Often the judges will say that that issue will be reserved for the final hearing and that for now both parties need to contribute equal amounts. And then often by the time you get to a final hearing, things settle, so the issue kind of disappears. But it is something you can ask for and may be successful, especially if you can prove a big disparity in income. Both parties need to cooperate with the guardian ad litem. It doesn't do anyone any good to be rude to the guardian ad litem or to not cooperate with their requests. If the guardian was requesting something that seemed inappropriate to the client, by all means the client should call you, discuss it with you. And I also recommend that my clients call me when there's a problem instead of just calling the guardian ad litem. Not only will the guardian incur fees for talking to the client, but also there may be some privileged information that is not in our advantage to share, or perhaps I can be the filter and explain the information that's relevant to the guardian ad litem, which may save his or her time as well as my own. So I do recommend my clients come to me when that happens.
Yeah, I don't think we can overemphasize enough that you need to emphasize to your client that the guardian ad litem is not their confidant.
Also, I recommend sending all the pleadings to the guardian ad litem and any other helpful information that you can. Like I said, if you have extra affidavits, even if you didn't use them in court, you could send those to the guardian. I do recommend sending all the affidavits that were filed at the least. If you know your client's children's teacher and the school they go to, you can send them that information. I mean, just anything that makes their job easier will ultimately limit the fees for our clients. Also, make sure you include the guardian ad litem when you're talking about hearing dates, scheduling hearing dates, or scheduling mediation, because they have busy schedules just like we do. So don't forget to add them to that email chain with the opposing party's attorney when you're trying to figure out dates. Also, another thing with domestic violence victims is you can help educate the guardian ad litem if some of the factors for custody make your client look bad, but they are really caused by the violence. So, for example, if the opposing party made it so that my client couldn't have a car and did that on purpose as a way to control him or her, then I might help explain that to the guardian ad litem, which might make the guardian ad litem view that issue a little bit differently. While it's not ideal to have a car, perhaps the guardian will consider whose fault that ultimately was and not use that as harshly against my client for custody determination. If you do not have an agreement, you will have to do mediation with your client and the opposing party. You can file a motion to exempt mediation for various reasons, such as the opposing party being in jail or some severe domestic violence if you don't think that it can be handled in a fair way. I do encourage my clients to try mediation when we can make it safe. In the 10 years I've been doing this, I've never asked for a motion to exempt, though that certainly is possible, and there are some reasons you may want to do that. Most of the time, we can get the mediator to understand the harm and work around those issues. For example, the parties could mediate by phone. We've had cases where we asked for the mediation to be at the courthouse because there was better security at the courthouse. There are ways, but you do need to inform the mediator if there are concerns like that for the mediator's safety as well as the party's safety.
Mediation is not free, and what you might consider, depending on where you are geographically, is looking at one of the mediation nonprofits. For example, in Greenville, we have the Upstate Mediation Center. So those are low or no cost, and that is really helpful for clients who can't afford the cost of paying for a mediator.
They are a lifesaver for us. There's also the Midlands Mediation Center in Columbia, and there's no maximum to use those mediation centers. So even if you have a client that has higher income but is stressed financially right now, you could still call one of the mediation centers and ask to use their services. You should know that if you reach an agreement at mediation and the parties and their attorneys sign the mediation agreement, that it's going to be very hard to back out of in the future, which is of course one reason we like clients and parties sometimes to sign these things, is because parties tend to go back and talk to their sister who had a cousin who had a boyfriend who was so-and-so, and that person thinks that they could get a better deal. So sometimes it really is advantageous to go ahead and get people to sign that memorandum of understanding or the mediation agreement, but you do need to be aware of that and warn your client what the implications of that are. If between the signing of that and the hearing to approve the agreement, if there is violence that changes things, that should be a reason that you can use to ask the judge not to approve the order, because there has suddenly been a change in circumstances that may not be in the best interest of the child anymore, and there's been some coercion and duress there. Before you file a hearing, before you request a hearing, you're going to file the mediation report. A few other hearings that may occur, there may be additional temporary hearings after the first one, especially if something has changed before a final hearing. Some jurisdictions have pretrial or scheduling hearings, especially if you're asking for a long trial to be scheduled. And usually at these we trade witness lists as well as talk about whether there's any discovery that needs to be answered. A rule to show cause can occur if one party has violated the order. Once again, that's the situation, the opportunity for a client to prove that they were not in willful contempt of the order, but it would be better if we just avoid the contempt to start with. Also, motion to compel discovery if one party is refusing to cooperate with discovery. And to request a hearing, some motions you can use an actual motion form that explains the motion, but often we use the hearing request form, which is available at the SC Court's website. And for the final hearing, we recommend that you prepare your direct and cross-examination. Make sure you talk to the witnesses, prepare your exhibits, and to be prepared for last-minute settlements. I've had so many trials that I have prepared for and they ended up settling at the last minute. So I try to work in time for that, knowing that that might happen. So I do recommend getting to the courthouse early so that there is time to talk about it, as well as advising your client to make sure that there is time to get there early to talk about it. I think that last-minute stress induces a lot of people to go ahead and make a decision instead of leaving it up to the judge.
I think too, always remember that if you did exchange discovery with opposing counsel, that you have a continuing duty to update that discovery. And I've actually won on a couple of occasions where I objected to a witness that opposing counsel was going to call, or a piece of evidence that opposing counsel intended to use, because they didn't update their discovery. They were things that specifically should have been turned over in the discovery process, and they weren't. So make sure that you're cognizant of that and that you're doing your due diligence and turning over any information that was discovered after you exchanged initial discovery. And I think a really good point for us to make here, particularly in the context of working with domestic violence survivors, one really key aspect for them is a loss of control. When you're a victim or you're a survivor, you've lost control over your life. And one nice thing about working out a settlement or even at mediation is the survivor retains some control over the outcome of this litigation, whereas if you go into a final hearing, that is ultimately in the hands of the judge. And of course, you could appeal if you felt like it was an unfair decision or something like that, but I really like to talk to my clients very early on and keep reiterating it throughout the process. I'm not trying to make you settle because I'm lazy or because I don't want to go to trial, but if you settle, or we work things out in mediation, you have a say in the ultimate outcome. And I think that's really important when you're working with survivors of domestic violence.
Also, if you can work out an agreement, it lowers the danger. Because if you have a trial where your client and several people they know are talking badly about the opposing party, everyone's going to leave there even more upset than they were when they started, and more angry and more hurt. So it's a time that an opposing party could lash out. Whereas if you settle, then both parties are involved in the agreement. Usually both parties feel like they have given, but they've also received a little bit, and are just less emotional, less angry about it.
Also keep in mind that the guardian ad litem would be attending the final hearing, and so sometimes that's important to your clients, that they'll be accruing those guardian ad litem fees during the course of one day or multi-day litigation.
Don't assume that your client knows how to dress for court. Be blunt and be clear about what's appropriate and what's not appropriate. I've certainly had cases that I thought, well, this case is just too sad. I can't spend time talking with her about what she's going to wear because I think she's going to be fine. Every time I've seen her, she's fine. And the facts are just so sad in this case. I hate to talk about something as silly as clothing. And then really regretted not talking to her about clothing. So,
or him.
Or him. Yes. That's true. I've heard all sorts of stories from people showing up with t-shirts with marijuana leaves on them to clients with thigh-high boots on. And some clients think dressing up is like a prom dress. So you never know, but it is worth having that conversation for your client and also them informing the witnesses.
And Leslie's right, be specific. Don't say something you would wear to church, or fashion is very subjective. So I would be very specific about the things that are and aren't appropriate to wear to court.
We've been talking primarily about custody and visitation cases that are separate and they're not part of a divorce, but just so you know, if it is part of a divorce, you're going to need to allege one of the divorce grounds in South Carolina or to ask for separate maintenance. And I often ask for separate maintenance as a backup because even though I wouldn't ask for a divorce on the grounds of habitual drunkenness or physical abuse if I didn't believe that we had real reason to do that and proof to back that up, sometimes the proof disappears before you go to court. The witness moves away, they're suddenly not willing to testify anymore. The record you subpoenaed didn't turn out to say what you thought they'd say. So asking for, in the alternative, a separate maintenance order can still provide some relief even if the divorce grounds aren't proven. And I also find that often by the time we get into court, even if we alleged fault grounds, it's often been a year by the time the process has gone through, and so we will agree to ask for a divorce on 1 year separation. So the way we do that procedurally is I will make a motion to the court to add the grounds of 1 year separation to our complaint. The judge will then ask the opposing party, do you object to this? They typically don't object because at this point we often have an agreement. Also, defendants don't really like all their bad laundry to be aired if it's not necessary. And then the judge will ask, do you waive your 30 days to respond? Because if I was to amend the complaint, they would have 30 days to respond. So if I'm dealing with a defendant who's pro se, I like to explain that to them, what those questions are that the judge is going to ask. Because sometimes when the judge starts asking them, they're a little hard for the pro se person to understand. But if, in addition to the divorce grounds, you should also discuss property division and alimony in your case and what the law says about those in your particular case. And there are factors for both of those to consider. You should also warn your clients not to remarry until the order is signed. You'd be surprised how many people go to their divorce hearing and then go to probate court and try to get married right away. I warn them multiple times, you cannot get married until this order is signed. First of all, it's going to take me a little while to get the order to the judge, and we don't know how long it's going to take the judge to sign it, so don't schedule your wedding. I've had several people say, but it's scheduled for next week. Don't schedule your wedding. Just chill, wait till it's all done before you move on to the next chapter. And also, when you send in the final divorce decree, you're also going to have to send in a report for vital statistics. Whenever you do a divorce, that's required, and that is also on the SC Court's website.
And you'll need to, if this is a divorce action and your client wants to change their name, you'll need to formally ask for that either in the pleadings or at a final hearing so that the judge can order the name change.
That's a great point, and it's much easier to ask for the name change at the time of the divorce than later on. They can either go back to their maiden name or a previously married name, and it's much, much easier. So even some of my clients who think that they never changed their name on documents, we often ask for it as a precaution because sometimes they'll find that they did sign a few documents that way, so it's better for us to be protected. Mm-hmm. There are a few family court rules that are often overlooked that I just wanted to mention. The 365-day rule, if the case goes over 365 days, it can be dismissed and often will be dismissed. And if it's dismissed, the temporary order goes away. So that's a really big deal. If you have temporary relief that's important to your client, such as temporary custody or temporary child support, and suddenly you waited too long to ask for a hearing or an extension, which you can do, and they suddenly no longer have temporary custody nor are receiving temporary child support. So when I file cases, if I feel like it's going to be a long case that might get into that 365, sometimes I'll go ahead on my calendar a year and mark it there just to make sure, or look through occasionally to figure out what's getting close to that 365.
And though the case might be, they're dismissed without prejudice, so you could of course refile the action, or you could ask to have it restored to the docket, which I've had to do one time, and it was very, very difficult. You don't want to find yourself in that position because judges are going to be incredibly unhappy with you. But it is prejudicial to your client who may have temporary relief. Like Leslie said, that will ultimately go away because the lawsuit has been dismissed, and it's often cost prohibitive. It costs money to refile a lawsuit and all of those things. So it's extremely important that you calendar the 365 days and that you wrap up that you've requested your final hearing before the 365th day rolls around.
Also urge you to look at Family Court Rule 7, which talks about certain documents that are admissible in family court without you having to worry about hearsay and other things. They're documents that are often used in family court, so it can save you some time and hassle if you remind yourself what those documents are. If you have a pro se person on the other side, someone who's not represented by an attorney, for the notice of the hearing, you have to send it by certified mail to the last known address. This time it does not have to be by restricted delivery, but it does have to be by certified mail. That's a tricky one because often when we have attorneys on the other side, we just send it regular mail, so sometimes we can get in the habit of doing that. But the rule does require, if it's a pro se defendant, that it is sent by certified mail. Also, you should know that the defendant, even if they don't file an answer and counterclaim, can still be heard at the final hearing about issues such as custody, visitation, child support, and all of these issues. So sometimes you get to the final, the opposing party's in default, they never gave you an answer and counterclaim, you go ahead and request a quick hearing thinking this is going to be easy, and they show up and they can object to those things such as custody and visitation. And in that case, the judge, if there's enough time in the case before the 365, will probably appoint a guardian ad litem. So I do warn my clients not to get too excited if things went really smoothly, and just remind them that the opposing party can, up until that last hearing, decide to object to those things. We appreciate your attention. We'll look forward to seeing you on the next segment.